I'm your host, Diana Longry. Thank you for tuning in. Off the Record News is a weekly news cablecast coming to you from St. Paul. Now, over the last few weeks, we have been reporting on organized trash collection in several different communities. Or in some communities, they call it coordinated trash collection. So it's all in the words you use, but in the end, it all means the same. That as a resident of that community, you do not get to choose which garbage hauler you would like to contract with to haul away your trash. In other words, who does the contracting? Who makes those big decisions? Well, it's the city. The city council makes those decisions, that they can decide who can contract better to haul away the city's trash than the individual residents themselves. Now, of course, these municipalities that have organized trash collection, they have other reasons that they set forth as to why they promote and support organized trash collection. One is that by having organized trash collection, it means then they can guarantee that there's going to be trash collected from every single residence or housing unit in that municipality. And that for some reason they believe that there are hordes of people in their municipality that are not hiring a trash collector and then are just disposing of their trash willy-nilly in the parks, in somebody else's dumpster, or along the roadways or in the ravines. Now, of course, there probably are a few individuals that do that. However, is it enough individuals to justify the city taking away the rights of residents to decide who they want to contract with when it comes to taking away their trash and being responsible residents in their municipalities? Well, now, this issue has come up in Maplewood, which we've covered, and they, of course, went to organized trash collection back in about 2012. And we have covered where they are now at the point where their 7-year contract, believe it or not, 7 years, that they tied the city to a contractor and left all the little trash haulers out of the game by going with the big monopoly. Well, anyway, in Maplewood, we have covered how they are going through their request for proposal phase right now because it's time to put out an RFP so that way they can engage a trash hauler in the collection of the trash for the whole entire city, and again, enter into a long-term contract, 5 years more than likely, with an option for a 2-year renewal. So again, 7 years. Now, we've also covered the issues that are going on in the city of St. Paul. But now, in the city of St. Paul, it's a little bit different because you see the residents of St. Paul have more rights to their governance than the residents of Maplewood. And you might say, well, how can that be possible? They're neighboring communities right next door to each other. How could it be that the residents of St. Paul have more rights in the governance of their municipality than the residents of Maplewood? Well, it all has to do with how that city is organized when it became a city. So for instance, Maplewood, when they organized to become a city of Maplewood back 60 years ago, they decided on the form of government of being a Plan B city, a statutory city. And that means that they go pursuant to a certain set of statutes under state law that says that they have a city manager who runs all the day-to-day affairs of City Hall, all the hiring, the firing, the management, the making sure things are going smoothly, sets the schedules for everything. Basically, the one who runs the city. They are God of that city. Now, and what does the city council do? Well, they have a part-time position where they listen to the city manager, the proposals of the city manager, and then generally they get out the rubber stamp and say, yeah, the city manager's doing a great job. Let's just raise those taxes another time this year. Clunk, clunk. So there you go. That's pretty much the way it operates in the city of Maplewood, because they are a Plan B city. A city council only has authority over policy making, the creating or repealing ordinances, and of course approving the budget. In the city of St. Paul, as we've discussed previously on these programs, the city of St. Paul has a different type of governance. They are a charter city. So what that means is that you look to the charter to understand what are the rights of the residents of the city and how is the city run, because it sets forth how and the government is run, what kind of structure there is, and it's not set up for the city manager to be the god of City Hall. And that the residents of St. Paul have under their charter, which is like a constitution at the municipal level, they have the right of petition, referendum, initiative, and recall. And so that gives them that opportunity that if things aren't going quite right at City Hall, they can take it into their own hands, that if they have enough of them that come together and agree to sign a petition that meets the standard and the level of signatures required by the charter, that they can actually change things in their city. And of course, that's what's been going on in the city of St. Paul and the whole struggle and the case that was in Ramsey County District Court that we covered, which found in favor of the residents of St. Paul on behalf of the citizenry of the city of St. Paul. And so the judge found in favor of the residents and said that they had the charter on their side and that the petition that they submitted to the city to put the issue of organized trash collection on the ballot, that the city council should have and had to listen to that petition because it was a valid petition under the charter, it was timely, and it met all the requirements. And as a result, that petition asked that the question of organized trash collection would be on the ballot for the people of St. Paul to vote on it for themselves, rather than leaving it to only their city council members to make that decision. So now, tonight, we are going to turn to another city that is also facing this challenge. Now, they started their challenge a few years ago, and that's the city of Bloomington. The city of Bloomington is also a charter city, so they have that municipal charter and that municipal constitution for the people. But like with any municipality that is based on a charter, you need to read the charter to understand what rights the residents have of that community, because not all charters are the same. They are put together by a charter commission. They are voted on by the people of their community. So not all charters are the same. So if you want to know what rights you have under the charter, if you live in a charter city, you have to take that charter out and you have to read it, because it might not be like St. Paul's, it might not be like Bloomington's, it might not be like Red Wings. So you see, it can be very specific to that community. And in the city of Bloomington, their particular charter is a little different from the city of St. Paul in that the city of Bloomington, their charter says in that charter that they adopt that city manager form of government, but, with the big but the residents of the community have the right of referendum and initiative and some other rights as well. So unlike Maplewood, which is a city manager council structured as a Plan B city that does not give any particular rights or special rights to the residents, the city of Bloomington is sort of a hybrid in that it is a charter city that has decided that it also wants its city manager to run the city and the day-to-day affairs, but that the residents are not left out in the cold with no recourse when things go hinky at City Hall. So now you're getting the idea of how it's so important to understand how your community is organized as a municipality, because it has a strong bearing on the rights that you have in your community, because you cannot always count on the elected officials to protect your interests, because they have many other interests that are pulling at their interests and trying to get their vote. And oftentimes the residents are at the bottom of that list. So now we are going to tonight look at some of the film footage from the court case that's been going on between Jenison and the city of Bloomington regarding organized trash collection. Because here is the setup in a nutshell. It's not all the details, but in a nutshell, is that the city of Bloomington went to organized trash collection. There was a large segment of residents that was against the city council voting for organized trash collection. So they looked to their charter and they said, we want to bring an action under our charter to repeal that ordinance that the city council just made. And so as a result of that, and that action, that started a legal action between the city of St. Paul and this group of individuals, residents of the city of Bloomington. It went through district court, it went through appellate court, and now it's at the Minnesota Supreme Court. And it was just a few days ago on June 12th that they had their oral arguments in front of the Minnesota Supreme Court. And so that is what we're going to show you here tonight, a great portion of that film footage so that you can see the arguments of both the residents and the arguments of the city. And when you come away from this and put yourself in the place of one of the judges sitting on the bench, think to yourself, which argument do you think is most persuasive? So let's get started with our first clip.
Good morning. May it please the court, counsel. My name is Greg Joseph. I represent Joel Jenison, Mark Vanek, Bill Reichert, Russ Burnison, Sunil Lakramani, and the thousands of disenfranchised Bloomington voters who've been denied their rights under the city charter. This is a case about denial of voter rights under the Bloomington City Charter and Minnesota Statutes Chapter 410 in the context of organized collection of trash in the city of Bloomington. This is the second time before this court. Last summer, you correctly held that the organized collection statute provides ample room for local regulation, and measures exactly like the charter amendment before the court today. The final two remaining arguments before the court are also pretext for denying the charter amendment. First, the city of Bloomington is asking you to recognize a new legal construct that they call an improper referendum. The city is essentially asking you to find that a municipal ordinance is immune from a city charter amendment. Now, this is not defined in statutes. This has no case law support. This is impossible in its application because it results in countless unrepealable laws. And the Court of Appeals erroneously recognized this new concept, and we urge this court to reverse.
One of the issues that is going to be argued in this case is whether or not the charter and the citizens' rights under that charter can supersede the ordinance creation ability of the city council. And that's really the heart of what's at this Bloomington case, because, as I indicated, it's recognizing that it's going to be run as similar to a Plan B city, but yet they're giving the residents of the city of Bloomington rights under the charter. So that's the conflict that's going on. Let's continue.
Let's start with that issue. I think that I'm going to hear from Mr. Hoff that what's going on here is an attempt to bypass the different standards for referendums and charter amendments. How do you respond to that? And I get the question. I understand your argument that, you know, it's actually a greater burden from the standpoint of the number of petitions, signatures on the petition that need to be signed, all of that. I'd like to set that issue aside. And my question to you is the mere fact that there are different processes for the two of them, do we have a problem here?
Absolutely not. Absolutely not. The council and the voters are free to amend the charter to make a referendum requirement whatever they want it to be. But the state statute for 410.12 for a charter amendment is what it is. That's a state law. So we're talking about separate bodies of law. So the idea of expanding a referendum or an improper referendum, the city council and a city only has jurisdiction over certain things, and they can't touch the statute, Your Honor, if that answers the question.
Council, in looking at the authority of the charter, which I think we have to do as well, I note that in section 2.01, the charter relates to the form of government and says this charter establishes the council manager form of government. The council exercises the legislative power of the city and decides all matters of policy. How do we read that, and especially in conjunction with the powers in Section 5? Does that mean that we construe Section 5 narrowly?
No, it doesn't. Section 5 is there for a reason. But if we want to say that the city exercises the legislative powers exclusively, then we have to ignore initiative and referendum altogether. But even so, the charter amendment power in 410.12 supersedes that anyway. And there's a separate provision under Section 5 of the charter that ensures voters keep that power to amend the charter under 410.12.
Indicating this issue of whether or not the city council's right to legislate is exclusive over the rights of the residents to bring a referendum is what the conflict is. Because if you were to say that legislation and creating of policy is exclusively the purview of that city council, then it makes initiative and referendum rights of the residents irrelevant. And so what would be the purpose of them in the charter if you were to say that the city council has the exclusive rights of creating public policy. Because you see, generally speaking, initiative and referendums have to do with creating policy for the community. They're not to say, let's hire the new Parks and Recreation Director. So let's continue with our next clip.
Council, it looks to me like there's no dispute that sentence 1 of the proposed amendment would be a proper charter amendment. It looks to me like the dispute is over the second sentence. And as I read the second sentence, I'm thinking, and I think the City Council has identified this, that essentially it makes the charter amendment retroactive to 2015. Am I right about that?
I guess I don't know how to answer that question, Judge, because it would repeal the legislation that was passed in 2015. I guess there's no reason for it to be retroactive, but it would repeal that. So I guess in that sense, it would be.
Okay, and I don't see anything in 410, chapter 410, about whether charter amendments may or may not be retroactive. Do you have any insight on that? Is there any case law on that subject? Is there any reason? I mean, legislatures and city councils legislate retroactively all the time, but there's nothing that tells us in the whether it can or cannot be retroactive.
Your Honor, again, I don't think retroactive is quite the right word for it. It's not the word I would choose, Your Honor. But if you looked at it in a different way, anything would be retroactive. I mean, any ordinance that was passed prior to the passage of the charter amendment would mean that it would be a retroactive application, right? Whether it happens 2 months down the road or whether it happens 5 years down the road. You could make the argument that it's retroactive in repealing an existing ordinance no matter what, right?
No, you repeal an existing ordinance going forward. You're actually, this charter amendment, as I read it, actually repeals the ordinance going backwards and says that essentially if this amendment passes, the ordinance and anything that has happened since then is repealed. Am I reading that the wrong way?
Again, it's a hard one for me to answer, Judge, because you have to repeal the ordinance in order to void the contract. And we only have recourse to repeal the ordinance. We can't, there's nothing in the charter that allows us to directly address the contract. So the only way to do this is to repeal the ordinance. I'm sorry if I'm not answering your question well enough, but the idea of having it be retroactively applicable, I don't really understand.
Council, maybe this is...
What is the effect then of that second sentence? Explain to me exactly how you see that second sentence operating and what it accomplishes.
So what would happen is if, in the event this is passed by the voters at a general election or a special under 410.12, what would happen is that 2015-45, the ordinance that enacted organized collection, would be repealed. And without that ordinance is the legal basis for the city's contract with the haulers. So without that ordinance, the contract with the haulers becomes impossible. There's no legal basis for it any longer. So I don't see that it would be.
So, Council, that seems to me that would be retroactive. And is there a problem with it being retroactive? I think that's the question Justice Lillehag was trying to get an answer to. Is there an issue if it is retroactive? Does that cause a problem for you, or does it not matter?
I don't think it matters. No, I don't think it makes any difference. I don't understand how, again, we have, the city pressed forward with organized collection, as we know. This has been happening in Bloomington since then. Now, we can't undo the last 3 years and change of organized collection. So if the ordinance is repealed now, we still have organized collection for the last 3 years, no matter what happens. All it's saying is there's no longer a legal basis going forward for organized collection. That'd be our argument.
In a nutshell, what happened is back in 2015, when the city decided to go towards organized trash collection, they entered into a contract for the hauling of the trash in the city of Bloomington. And so this charter amendment that is being debated here in the Minnesota Supreme Court, and whether or not if it's going to stand up or not, that charter amendment is saying they want to repeal that ordinance back to 2015 at its inception. because therefore, if there wasn't an ordinance back in 2015, the city would have had no legal basis by which to enter into the contract that is currently in force with the trash haulers and the city of Bloomington. Now, there wasn't a clear answer about whether or not this causes a problem legally or not if you are looking backwards in time. But here's the other issue, is that if, for instance, let's say if these particular justices decided that that you can't go back in time, but it could be that it's not valid as of this date, well, then where does that leave the contract? Well, then perhaps there's arguments that there's still basis to say that that contract cannot go on because there isn't any ordinance to support it. We'll have to see what they come out with their logic on this, because certainly neither attorney in this case really had a clear answer to that, and we'll have to hear and read what the justices come up with when their order comes out in a few months from now. Let's continue.
The amendment has sort of all the trappings, if you will, of a referendum, because at the end of the day, what it does and what you're seeking to do is to repeal the city's ordinance. And I'm wondering if there's a case or out there that says that voters can bypass what would typically happen in a referendum process that's provided for in the city charter and instead repeal an ordinance by a charter amendment. I mean, what's the best case? Is there a case that supports that proposition? Because it seems to me that's what you're doing, or that's what you're asking to do.
And again, I would distinguish the two because there's no suspension function. Okay. All right. So there is no suspension.
Your argument really hinges on that this suspension function.
Well, that is half a referendum, but it's not just that.
Is there any problem with having multiple ways of repealing an ordinance?
No, I don't believe there is. And I don't believe there's anything in a charter amendment in Chapter 41012 that restricts that. There's nothing in 41012 that says you can't repeal an ordinance. So there's really no motivation to skirt a referendum in this case. As I pointed out, it's a lot harder to get a charter amendment as well.
We take anything from, or should we take anything from your client's actions? I mean, initially, that's what you thought was the proper mechanism. You filed it as you approached it as a referendum unsuccessfully. So this is something that's occurring after the fact.
No, I'm sorry, that's not correct, Your Honor. This was actually originally filed as an initiative, not as a referendum. And in the first case, it was found that an initiative wasn't the proper vehicle because it functioned as sort of an anti-ordinance. Okay, so because the ordinance hadn't been passed yet, it was sort of tying the hands of the city council as an initiative, and that was found to be improper, and it was suggested that it be brought as a charter amendment is the proper way, if that makes sense. Referendum did come later, but again...
Well, I guess that's my point, and help me with the record. At some point, you filed a referendum, right?
Correct.
And that was the document, and the city clerk said you had insufficient... Something was procedurally insufficient. I don't remember what it was specifically, but something was procedurally deficient, right?
We heard that a lot, Your Honor, yes, yes.
Okay.
So that's right. But again, at the end of the day, if you look at the charter amendment, it can't possibly function. I mean, you can't achieve with a referendum what this seeks to achieve. Because what this is doing is tying the hands not just of this city council, but of every city council going forward. And you're saying if you ever want to convert to organized collection, you have to get voter approval first.
The issue that the city of Bloomington is unhappy about is that the residents, in essence, took 3 bites at the apple. That the initially attempted initiative, and that wasn't the right vehicle under their charter. Then they tried referendum, but they didn't procedurally meet some of the requirements under the charter, according to the city. And then it was suggested, though, however, that they go and rather than use their charter provisions that they go to state statute, which addresses how residents who live in a charter community can go about making changes to their charter by an amendment to that charter. So that's where we're at this point, and that's part of the reason why this case has taken so long. It's had a lot of twists and turns throughout the years since 2015. Let's continue.
Going back, does the record tell us what happened in Jennison 1 when the initiative was put forth and it was deemed deficient? Did the city attorney do the amendments to make that legal, essentially, that was required, or does the record tell us?
No, Your Honor, if memory serves, it was rejected because it was preempted by state law, because it was an impairment of contract, because the city lacked the authority to, I'm sorry if I could just finish answering your question. The city lacked the authority to do it, and it was in improper form. There were several grounds, Your Honor.
Thank you, counsel. You have 20 minutes for.
Now, when you argue in front of the Supreme Court and as well in the appellate court level, each attorney has a particular amount of time in which to argue their position. And generally speaking, you don't just get to speak from some script. The judges have read the briefs and the file, and they usually jump in with questions right away. So you got to be on your toes to be able to answer their questions. Well, now, this attorney did a pretty good job of that, although there were a couple times there where he had to tell the judges, well, you know, I don't really have a good answer for that. And, well, you know, that's the way it is, because it's the judge's job to ask these types of questions that might stump you, because that is what, you know, they're trying to get to, those intricacies of the argument. So let's now turn to the city of Bloomington and their attorney and his argument. Let's take a look.
May it please the court, Counsel George Hoff and Shelley Ryan representing the city of Bloomington. The issue, there are two issues here, but the focus of the questions, and I'm going to start with the issue of—
Counsel, I'm going to ask you a question right away.
All right.
Before you even start. So if the second sentence were not in the proposed amendment, would you concede that that would be a proper charter amendment?
You know, I've looked at this thing for now 3 years, I think, by now, and I'm not so sure it is. And I think last time I was here, I think Justice Lillehog and I engaged in a soliloquy about the first sentence as well. It's an odd sentence in that it defines process, so to speak. And if you look at Vasseur, if you look at 410, 410-12, what it talks about is charter amendments talk about that you talk about the form of government, structure of government. That's the permissible method. And so I'm not so sure, given the way that is worded, if I may, if I were to say what would be a proper charter amendment, and maybe I don't need to answer this, but I will, is that it would be a straightforward, simple sentence that says the city does not have the authority to organize collection. So,
Counsel, let's try to wrestle this improper referendum thing to the ground. I've never heard the phrase improper referendum before. To me, something's either illegal or legal. So let's figure out what's legal here. Is there anything in this charter, proposed charter amendment, that violates Minnesota Chapter 410? And if the answer is yes, please point me to the specific provision.
There is it is in Chapter 410,
yes,
as opposed to Vasseur. In Chapter 410, if you look at 410-12, which is the amendment section under subdivision 1.
Got it.
What it says is the summary shall contain a statement of the objects and purposes, proposed, an outline of any proposed new scheme or framework of government, and shall be sufficient to inform the signers of the petition as to what changes in government are sought.
Okay, and how does this proposed amendment violate that sentence?
Because what it does is repeals an ordinance. When it's the second sentence repeals.
Well, does it contain a statement of the objects and purposes of the amendment?
I'm sorry, I don't know that I understand.
I'm reading the language you just cited
Right.
to me. Does the summary of the proposed charter amendment contain a statement of the objects and purposes of the amendments? It's talking about a summary. It's not talking about the amendment itself.
Correct.
Okay. So does it contain that?
Does this particular amendment contain it? No, it does not. Because
The
it
sentence
doesn't
you
have-
read to me relates to a summary that's put on the ballot, isn't it?
Correct.
Okay. And has that summary been prepared?
Not to my knowledge.
Then how does this charter amendment violate that sentence?
Because as I read this sentence, Your Honor, and as you read it, as this court read it in Vasseur, is that charter amendments deal with the form of government and do not deal with legislation, which is what this is. A referendum is nothing more nor less than legislation.
So the attorney for the city of Bloomington is almost stepped into a big pothole here that it's hard to tell if he's been able to rescue himself to get out of that pothole, because clearly he was going into an area that the judge had already really looked into, and this issue about the summary. Well, the point that the city attorney for Bloomington is making is that he's trying to convey that an amendment to the charter is supposed to deal with the structure or the form of the governance or the structure or the form of the charter and how it operates and how things are conducted under the charter. And that really the way that this was presented as an amendment to the charter is more in the way of a referendum and more in the way of policy and legislative actions, and that's why they have coined the phrase an improper referendum, and that it's the city's position that they've used the amendment to a charter under the state statute improperly to get around the fact that they weren't able to do their referendum properly. So that's the argument of the city of Bloomington in a nutshell. Let's continue.
So does the charter amendment propose a new scheme or framework of government?
In my view, again, in response to the prior question, in my view, if you want to separate, if we can separate the two sentences for a moment, I'm not sure that as I read it more, that does talk about a new framework or scheme of government, given what I would view as convoluted language in it. I think it goes to process. I think it could be cleaned up, so to speak.
So the city's position is that the sentence about the summary of the amendment actually operates as a limitation on the substance of the amendment.
In my view, yes.
Okay.
And that's also what
But can I just clarify that though? Doesn't that summary only, is this charter amendment more than 1,000 words?
No,
So is there a summary that's required?
no.
So what, I don't understand your argument then.
If you look back, I think what you have to look back at is it's also, if you have to look back, an amendment assumes it's amending something. An amendment doesn't come out of thin air. It's not an original document. And if you look back at 41007, and it has to be read in conjunction with that, it talks about the charter may provide for any scheme of municipal government not inconsistent with the Constitution and may
So
provide
what about
for the
provisions,
establishment.
charter provisions in other cities? I'm not sure if it's in Bloomington that set up rules about like hospital districts and you can't, and they set up very specific rules about what can and what can't happen with a very specific thing like a hospital district. How does that fit in with your argument then?
If you have.
So how is that different than this?
Sorry. If your question to me, Justice Thiessen, is in that example, if a charter contained language that says the city shall not have a hospital district, that goes to the form and scheme of government and goes to the basic power of the governmental entity.
And how is that different than the first sentence here, which is saying here, we're not going to have a specific form of another government function, which is waste hauling?
But we're talking, you can't, well, first of all, you can't separate the two sentences if we're talking about the improper referendum issue. You cannot separate those two sentences under this court's decision in Minneapolis HRA. If you recall that case, what it was is you had, I think there were 3 sections. 2 were blatantly unconstitutional. The third maybe was okay. And what the proponents argued in that case is, well, look, we've got a severability clause. Let's go ahead. Let us put the whole thing in front of the electorate and let it sort out. And what this court said at that time was that you cannot be a mind reader, and you have to submit the whole thing, and therefore you don't submit an ordinance or a charter amendment, which is unlawful. So you've got to read the 2 sentences.
And so as you are listening to this, you can hear how there's a feeling that the judges are skeptical of the city's argument and the city's position. Let's continue. Let's continue. Okay, our film clip has frozen, so we're hoping for a smooth transition here. But that's okay, it's live television and that's the way it flies. Now we, of course, have about 5 or 6 more clips, so I'm hoping that we'll be able to get them up and running so you can see the rest of this film footage. In this argument, there were quite a number of people who were in the audience, and because this was a case where a lot of people were interested in arguments of both sides, they didn't have enough room for individuals to be in the courtroom, but they had there's another overflow room where people can be that can watch it through closed caption cameras, and you can watch it that way. Now this film footage is available online, so if you would like to see the arguments in their entirety, you can just type in the name of the case, the Jennison versus the City of Bloomington, and you will be able to find that film footage with a little help of Google. And then you can watch it, because you see one of the aspects of this type of oral argument, as I indicated, each attorney has time in which to give their main argument. And then they have time in which they can then have rebuttal. So in this particular oral argument, it's my understanding that each of the attorneys, after they each got their opportunity to give their argument and answer questions, that they each had 20 minutes to give their rebuttal to what the other attorney said. And so we are not going to have the rebuttal arguments here on this program, but like I said, if you're interested in hearing the rebuttal arguments, they are available and that you can watch them on the internet. Now, there's a lot of interest in the outcome of this because, as I indicated, with the case coming out of St. Paul that was argued and then the decision was issued out of Ramsey County District Court, there is the potential that, of course, that case being appealed could be a very lengthy and long case just like this. We don't know. But as you can hear from the arguments, they are building on a lot of other cases that come out of cities and municipalities that have charters and that have talked about and challenged the rights of the residents under their charters to bring initiatives or referenda or to amend their charter in order to have the municipality take action in a way that's consistent with what the residents would like to see rather than what the elected officials enacted. Now, of course, there's one point in the argument where one of the attorneys mentions that, well, certainly a recourse for the residents of any community, whether it's a charter community or not, that if they don't like the ordinances that have been passed by their city council, that they can get involved, that they can bring that to the ballot box, that they can run for city council, that they can get that person unelected. And yet we all know that that is not as easy as that, to just simply say that, because in so many municipalities, the positions, while they are supposed to be nonpartisan, it turns out that they are very partisan, that the political parties have gotten very entrenched in the municipal politics. And so even though they are nonpartisan, it turns out that they really are partisan elections, and you have to have a lot of money, you have to have a lot of support, and you have to have endorsements as long as your arm. Well, let's continue and return to our film footage.
Council, you referred to section 410.07 and what charters may contain.
Yes.
And you read part of the sentence. The rest of the sentence says, and for the regulation of all local municipal functions. Does this charter amendment provide for the regulation of the local municipal function of trash?
Are you talking about both sentences or the first sentence?
Well, I'm talking about the sentence you were quoting from 410.07.
I'm sorry, are you talking about both sentences of the proposed charter amendment or just the first? In response to that
Let's start
question.
with both.
With both, then it exceeds that because it's directly repealing a pre-existing ordinance.
And that's not the regulation of a local municipal function?
No, that's legislating.
Okay, would you concede the first sentence is included within regulation of local municipal functions?
Subject, and I don't want to repeat my concerns about the convoluted language.
Yeah.
The answer is, if properly framed, that could potentially be the case.
Okay.
But
What do you make of section 5.09 of the charter, which says nothing in this charter affects the right of registered voters to propose amendments to this charter in accordance with the Constitution and statutes of Minnesota?
I agree that's there.
Good, we agree it's there.
Thank you. Yes, I will agree with you it's
there.
there. We can both read English. And even if it wasn't there, they'd still have that right. It's put in. But I think, again, what you have to read is you look at 410.07, you have to look at 410.12, and that what you come away with, and then this court's interpretation of Vasseur, is that, and it's the legislative function, if you look at 2.01 in the charter, that says all legislation is powers vested in the city council, except as otherwise provided in the charter. And then what Bloomington did, unlike other cities, is they included referendum within it. And therefore, what has happened here is that the Bloomington residents chose a form of government. They chose the Constitution, if you want to use that term. And what they did is they had specific parameters for how they were to be governed. The council controls everything legislatively, but there are certain strictures or certain areas where the public can weigh in by petition. And the only way that's provided to repeal an ordinance is by referendum, and it was specifically included. And that, therefore, that is what you have to go under. And
as he was indicating, in that City of Bloomington charter, there is a provision that if the residents of Bloomington want to repeal an ordinance, that the way that they can do that is by a petition that meets the requirements for a referendum. But as we heard in the earlier clip, the question is there really only one way in order to repeal an ordinance? Certainly there is one clear way to repeal an ordinance in the charter for the City of Bloomington, and that's by referendum. However, the question is that these judges are asking is, why can't you also do that with an amendment to your charter that talks about organized trash collection being a system or a policy that is not going to be permitted in the city of Bloomington unless it is brought to a vote of the people. Let's continue.
I think what's perhaps lost in all this case and Mr. Joseph's eloquent argument about the rights of voters and the rights of citizens, what about the rights of the citizens who voted for the charter? They have an expectation that the charter will be followed. They have an expectation that that rule of law that was established by that charter will be followed.
They voted for the charter, but they also voted for section 5.09, which says the charter may be amended.
I agree.
So,
But-
and then if they have another vote, they can vote for or against this proposed amendment. So how does that reduce the rights of the citizens of Bloomington?
Because, Your Honor, if you've got an ordinance, and let's forget this ordinance for a moment. Let's talk about an ordinance that deals with how big a fence can be, for example. Is what happens is that the ordinance is passed, 15 days past the effective date, and then people go ahead and control their behavior in accordance with that ordinance section. And then all of a sudden what happens is that later in time, just by virtue of a referendum, you can go ahead and undo that kind of regulation. That's not the anticipation. There is an expectation, in my view, with the residents of Bloomington that ordinances will be legislation permanently subject to either later control or later repeal by the city council after they have due consideration. And remember, we are talking about a representative form of government here. That is what the people of Bloomington chose. They didn't choose, for example, the Wild West, I was about to say, of California with endless initiative proposals, but that's what they've chosen.
But is having the right to referendum the Wild West, and that it's just willy-nilly people out for themselves? That's not the way it works, because in order to get that referendum to the ballot, you have to have organized enough people of your neighborhood, of your community, to sign a petition who have come together, and it's not everyone, and it's available under the charter, and then it goes to the ballot and the people vote on it. So you see, it's not the Wild West. That's not quite the analogy that I would have used if I would have been arguing on the side of the city of Bloomington. Let's continue.
Counsel, could I ask you, how about the St. Paul human rights case? How do you distinguish that? Because I know it involved an initiative, but there the rationale of our court was that because there was the initiative recall provisions in that and other language that's similar to the broad language in the Bloomington, that an initiative could actually repeal an ordinance.
Your Honor, that's the law of this state, and I obviously don't disagree with it. And I think what that addresses is Mr. Joseph's comment, which I don't think he got any questions about, is, quote, "This is an unrepealable ordinance." It is not an unrepealable ordinance. There are remedies that are available to the citizens of Bloomington. First and foremost is the old phrase, throw the bums out. File for election, get on the council, make some changes. The other is by initiative. And the important thing to understand about initiative is, again, what the residents of Bloomington did in establishing their charter, their constitution, is they had a reasoned method of dealing with initiative. You file a petition, and if I remember right, it's section 5.07 of the charter. And what that provides is that there is a petition with respect to initiative. Then the council has to take a look at it. There's a 65-day period, and then there is a public hearing requirement. The council then can go up, down, or modify. If it's modified, then what happens is the petitioners have the opportunity to decide, is that something we like or not like? And so it's a much different process. But that is available to, leaving aside the contract issue, I'm not talking about the impairment issue here, that is a remedy that's available to them, and I see them as entirely distinct cases.
Can we go, sorry, go ahead.
Well, just to follow up then, so the distinction is that the charter amendment is a totally different animal, and you rely on this, basically the state statute that says you can't do this type of thing with a charter amendment.
I rely on several things. State statute, this court's pronouncement in Vasseur, and the way, if you just look at the structure of the charter. If you start at the top, legislative authority, city council. Some reservation down here by way of leaving aside recall, some reservation down here for initiative and referendum. And that is it's those two things that allow the exercise by the citizens of legislative authority with respect to ordinances within the city.
Now, one of the judges spoke out about how she felt that the city, knowing that there was these rights that the citizens and the residents of Bloomington had under the charter, that the city, knowing that, did not work with the residents to resolve the issues, and that it's had to come to this, that this case has been going on for years and years and years, and that it's just gamesmanship. Well, that, I thought, was strong words coming from the justice that has been reading all of the files, that this case has come before the court previously on another issue. And I think that it will be very fascinating to hear and find out what their final decision is going to be when it's issued in a few months. And we certainly will let you know what that is. Now, I hope that you've enjoyed our program this evening and the coverage of this oral argument at the Minnesota Supreme Court and the case of Jennison versus the city of Bloomington. I hope that you go and watch the rest of the film footage that they have out on the internet, and we'll see you again next week. Thank you for tuning in. Bye-bye.
Council, what I don't understand, what I have a broad picture problem with is that you have initiative, you have referendum, you have charter amendment within your city charter. I don't understand why actually we're here from 2014 to present, when you have those options available, why the city didn't just work with the residents to address this issue. I have a real problem with that because they do have the options, and it seems to me a little bit of gamesmanship.
I understand the question, and I'm here as the appellate advocate for the city, and I was not involved in any of those discussions. I think that the issue of whether or not the city had an obligation to say, you know, here you go, here's what you need to do, I don't think any obligation like that exists.